Oppenheim. I'm an attorney in the Public Defender's Office in Baltimore City.
So just thank you, Todd, for just agreeing to kind of discuss this with us. I know this is something that we're all dealing with now, BALT, and we're dealing with a lot of bail and electronic monitoring, and I just know that you working in the Office of the Public Defender is something that you deal with every day as well. Before we get into the content of the webinar, I just wanted to ask you a couple of questions so that people can be familiar with you and what you do. Before that, I'm not sure who's familiar with BALT, but I can just give the quick spiel for BALT really quickly. And BALT, or Baltimore Action Legal Team, we started around 2015, providing emergency legal response during the Baltimore uprising. We eventually transitioned from 5 co-founders who were really doing the work on a volunteer basis while all having full-time jobs, to now we're a team of 4. We're mighty but strong, to a small but mighty team. And we have work that really focuses on 4 areas, which is direct assistance to people, and that looks like our bail fund, or covering electronic monitoring fees, and this is during the within pretrial area. And then we have litigation, which Matt leads up a lot of our litigation work. We currently have litigation with Baltimore Police Department, State's Attorney's Office, and something with the Civilian Review Board. And so our litigation mainly focuses around injecting transparency into Baltimore's justice system. We also have a lot of advocacy work in which we work to, in addition to providing direct assistance, we want to make sure that we create awareness around the areas that we focus on, and we really do intentional focus to push and shift the power. And then lastly, I'm blinking on the last one, and I had it in my head, I cannot remember. I will say that we are also the program manager for the newly launched People's Commission to Decriminalize Maryland. And so you all will be hearing about that a lot. There will be a webinar on that as well, July 29th. I'll make sure that I put the webinar registration link in the chat box. So so Todd, on to you. Just want to talk about your work with the Office of Public Defender, or OPD for short. How long have you worked with OPD?
About 17 years.
All right, so you're kind of new to this.
Yeah. I think I've held every job that you can, working your way up to where I am now, which is I handle felony cases, and I'm the supervisor with a team of 9 attorneys.
Gotcha. So what do you hope to gain from this webinar? What are you hoping that, the attendees will take away?
Well, I write articles on the justice system, and I speak, and I've put this presentation together before, but then kind of revamped it and worked with you guys to make this really relevant now. So for me, talking and speaking and writing about the system is very cathartic, because I find that I'm often butting my head against a very firm wall, and we get very frustrated in our work. But hopefully we'll have a somewhat sympathetic or at least open audience to the arguments that we're going to be making, and the points and the information that we're going to be providing here. So it's nice, and I want to be able to take audience's feedback and questions, and kind of check myself as where I'm coming from. I hope to discuss systemic racism, and give people that are really fired up about what's going on, or have been, and really feel the movement that's going on now, give them some meat as to like what they can really tell people about how bad the system is and what improvements we can make. But I also realize that I'm a white guy making these observations. My clients are mainly African-American, and I've been doing it for a while. So it's always important for me to check myself in that respect, and take in people who are actually experiencing racism firsthand, versus me, who I see it through my clients and experience it in the courts and where I live in Baltimore.
And then really quickly, lastly, before we begin, what do you think is the biggest misconception with the pretrial system in Maryland, or lack thereof?
Well, we had some really big reform that went through in 2016 and then went into law in 2017, which there's a general misconception that we fixed the bail system, that there's no more bail. We did fix it, but there's definitely still cash bail. It's not as prevalent, but there's new problems. And it certainly is nowhere near perfect. And it's really hard to understand that without hearing it or watching it firsthand. But I think once it's broken down, it's pretty easy to pick apart. And there are some really basic and obvious solutions that we just haven't come to yet. And I think this crisis is really, like with a lot of aspects of society, really opening up some wounds that we're going to have to deal with. So now's the time when we can really maybe seal the deal.
Well, thank you for that. So before we get into your presentation, I just wanted to do a couple of housekeeping things. This will be recorded and we will actually post this on our website. And then also, if you would like to use questions, we are taking questions. We're going to use the question and answer feature in this webinar. And so if you look on the bottom panel, you should see something that says Q&A. Feel free to ask your questions, and then at the end, I'll choose a question and then we'll answer them. And then also, if you all can, we want to build community as much as we can. So please introduce yourself if you would like in the chat box. Introduce your name, your pronouns, and your organization. And definitely feel free to have discussions in the chat box, and I'll try to pick some out there. But if you want questions answered, we're asking that you use the question and answer feature. Anything else before we begin, Matt or Todd? All right, well, I'm going to turn it over to you, Todd.
Thanks, Iman. All right, the pretrial injustice system. So we're going to take a look inside the bail review process. I want to keep your attention right away, so we'll go into something that kind of grabs you. How does this work? Okay, there we go. All right. Well, it's hard to ignore that outfit. But pretrial status, the bail review itself, it's kind of a basic proceeding for most attorneys. We don't think much of it, but it's really important. And the outcome lingers with someone throughout the life of a case. And like the great philosopher Eddie Murphy used to say about a certain malady that we won't get into right now, it kind of sticks with you like luggage, and you can't get rid of it. For our situation, obviously, it's a lot more serious than what he's talking about. That's why I got his serious face right there. But it sticks with you, and we're going to talk about how it impacts everything. And it's really, when you get a ruling that goes against the client when it happens, it really is defeating, because sometimes we'll know what's in store because of what happens at the bail review. So let's say that you have an African-American friend, and it's a young male, maybe not necessarily a young man, I guess early 20s, driving in a car. They have supposedly have some issue with their taillight. They don't think so, but the officer certainly does. They pull them over. They had some small amount of marijuana in the vehicle, but they think that marijuana is now legal. It's been decriminalized, which means that it's not a criminal offense, but it is still technically something that an officer can give you a civil citation for. So the officer says, I smell weed. What are you going to do? You need to get out of the car. The guy, is not happy about that. They feel that they have the right to not have their car searched. They think that they were pulled over because of the color of their skin, maybe the appearance of their car. So they protest. They give some lip back to the cop. Next thing you know, they're pulled out. They're having words back and forth, and the guy gets booked and charged with resisting arrest, assault, disobeying an officer, the trifecta, which usually means the officer did something wrong themselves. But they're going to jail at that point. So what happens when you go to jail? You go to central booking. That's central booking. That's Madison Street, the entrance on Madison. You're going to go and you're going to probably be held in a holding cell until a commissioner becomes available. A commissioner. There's about 300 commissioners throughout the state. These are not lawyers. They are required to have a college diploma, but no real expertise in the law, which you would think might come in handy when dealing with matters of the law, especially like whether someone's going to continue to be held in jail. But that commissioner is going to be setting the initial bail situation as to whether they're going to be held, whether they're going to be released and given a summons or a little note saying when you come back and go to court. And so the idea is that you're supposed to see a commissioner as soon as possible. They're there 24 hours a day. They rotate in shifts. But obviously, like during the uprising a couple years ago, BALT was very integral in this. When they get overwhelmed, you could be sitting there for days just to see a commissioner and get released. It's not necessarily that commissioner is going to say you got to continue to be held, but you got to see them to get the process going. So they have tremendous power. There's a lot of it that's set because the legislature doesn't want them, letting out Mr. Murderer. There's always Mr. Hypothetical Murderer that we got to be afraid of. So they are in central booking, and as of about 5 years ago, it was determined that people have a right to have an attorney there, which you would think makes a lot of sense because the state's attorneys send in a piece of paper with basically a written recommendation arguing their case. So it makes sense that somebody ought to have a lawyer next to them arguing their side as well. We do not staff that. There are private attorneys that are paid by the state, and they work in shifts as well. They work overnight, and they do those hearings. What we're going to get into, though, is basically the result of the commissioner who says you have to stay in jail longer now, because that is a bail review. So that's where the term bail review comes up with. It is an initial bail hearing that is reviewing what the commissioner did during the first step. So the commissioner's got to happen generally within 24 hours of your arrest. You got to see that commissioner. It can be quick. It's usually going to take at least a couple hours, though. The bail review, though, is really the next business day. So my advice to you is don't get arrested on a Friday. God help you if it's a 3-day weekend, because we all know that the government ain't working on Monday. And judges will not, we don't have night court. I'd love to do it, but they don't. They do business hours. And if you get arrested later in the day, you're probably going to be pushed over an extra day. So that's where we're going with this. And it's really interesting, too, because there's some strategy that comes into play. A commissioner can set a bail amount that could be attainable from someone. And if the person is savvy enough, or if they have access to an attorney, probably going to be a private attorney at that point, because we're not going to get involved until the bail review the morning of, when we go and interview people, and I'll talk about that in a minute. But you could essentially preempt the judge and get out of jail if you have the savvy to do that. And a perfect example of that happening was when the cops arrested for the murder of Freddie Gray had bail set. They were high, but they were met. They did that before they ever saw a judge. They did it in the gap period between the commissioner and the bail review process, and they got released because the judge could change it and hold them without bail or raise the bail. So this is me. I'm a public defender. Most people understand that we are lawyers. Some of them don't. Some of the people who have actually found my client's not guilty have asked me after trials if I considered going to law school, and I said I'm still debating. The jury's out on that. That's what I tell them. But there's no difference. We are the exact same. We have the exact same education. We abide by the exact same rules. We generally work in one courthouse, though, or one county in Maryland. We represent people who can't afford paid lawyers. Most of our clients, it's really changed, and we'll talk about that, but I would say a good portion of our clients are in jail, especially where I work, which is in a felony unit. We go to trial a lot, simply because the number of clients that we have and the way that we know the system. We also have a lot of clients who have a lot going on with their records, and because of that, we're often in situations where people can't work things out because they're on probation or parole, and we end up having to go to trial. I, in my unit, handle felonies, which includes drugs, still, rapes, robberies, murders. I work in circuit court, which is downtown. We'll explain the difference between that in a minute. And I still go back and do bail reviews about once a month. That's what our office basically does. And when I started, I spent about a year in jail, central booking, not incarcerated, but doing bail reviews. So district court and circuit court. If you get a traffic ticket in Baltimore City or anywhere in Maryland, you go to district court. That's the, if you will, the MVA, the Motor Vehicle Administration of Courthouses, kind of a hodgepodge mess of things where you're really not sure if you're in a third world country, whether the laws of our land apply, the formalities of court are kind of out the window. And it's just really a sad place because you've got a mixture of all kinds of actions going on where a lot of people's rights are at stake, not just in criminal cases, but you have a lot of landlord-tenant issues going on, stuff like that. But those are generally going to be minor actions that are happening there. That's where misdemeanors are handled. But this is also where the bail review is going to take place. And by take place, it doesn't exactly happen like you would think it would, but this is the courthouse in the bottom bottom left-hand corner up in Northwest Baltimore called, we call it Wabash, up on Wabash Avenue. And we're there, judges there, just that our client is not there. And we'll talk about that in a minute. Circuit court, you're gonna have jury trials. That's where you go for jury duty. It's downtown. It's actually broken into two courthouses. High-end, for civil cases, that's where the high-end lawsuits come in. But it's also very important to note, because we'll talk about what's going on with the COVID crisis. It's a place to file a secondary bail review, a second shot at it, which is generally called a habeas petition for habeas corpus. It's basically to say that something illegal happened at the first bail review, and therefore you're entitled to a second bail review. Very difficult to get that in normal times. Right now, not so much. They're happening. Secondary bail reviews are happening. We'll get into that in a minute. But they do occur just real infrequently when courts are normal. Nothing is normal right now. We'll talk about that. So at the bail review, it seems like once the court proceedings start, it seems like a court proceeding. You have a judge on the bench, the defense attorneys involved in the bail review are going to, I would say 9 times out of 10, be public defenders, mostly because most people don't plan out their arrest. So if you have a private attorney that you normally work with, it's just real difficult to get in touch with them once you're arrested, and who knows what their schedule is. You can see Jackie Childs right there. He's not going to just run into court and represent anyone unless the money's right. So it's normally us. What's crazy is what we have to do on the day of bail review. I call it the PD shuffle. We have to get to central booking where everybody is from the night or day before by about 8 in the morning, and then within about 2 hours, you got to go through the charge papers, basically maybe work up and make some phone calls, interview the clients, which is a real sticky situation because the phones are really difficult to communicate to the client with. Passing notes back and forth, it's really hard to show them a report or something like that. And they have to kind of stand up while you're sitting down. It's not a great situation. But you got to get that done. Then you got to drive up to the Wabash courthouse and get in the courtroom with your stuff all together, maybe do some follow-up work, print out stuff, get some motions written up and ready to go for your docket. Now, there used to be a courtroom in Central Booking when I started, and we did bail reviews there. They still had to do them at Wabash, and women's bail reviews have always been done at the Southern District Courthouse, which is on Patapsco Avenue. But our office is now, they basically shut down that courtroom, in my opinion, because the judges don't want to come to the jail anymore. They threw us out of our office, which was across the way, and kind of redid that old courtroom, which is just a cement mess, and put up partitions. Now we're in the refurbished courtroom. The office that we had before was taken over by the warden of the jail. So no hearings go on there. And the key to that before was that the defendants were there with the judge in the courtroom. So at the bail review now, you have a state's attorney who is a prosecutor who's just doing all of the cases, just kind of feeding the same information on most cases based on the charge. Doesn't really know about what, footage shows in a certain case, whether it's body camera footage or whatever. You also have a pretrial services investigator who's a part of it, and they get to give a recommendation. So you have, generally they go first, then you have a prosecutor say what they want, and then defense attorney says what they want. The pretrial services investigator is not an attorney. They are supposed to be neutral. They're supposed to be presenting background and record of the defendant, and then a kind of a neutral recommendation that's coming from them. And they are also the agency that could be charged with monitoring, and you'll hear about how limited they are in that, but they have the ability to do that, kind of like a pretrial probation agent. So they're assessing whether they want this person out under their supervision based on charges, and they're kind of restricted too by guidelines based on the charges. There have been some serious changes in the bail laws, and the pretrial services people, they were very state-oriented. They still are sometimes, but they have really come around and taken a more holistic approach about the detriment that pretrial incarceration has on clients, and we'll talk about the reforms that have been made to the laws. And I genuinely feel that pretrial has taken those reforms into account in making their recommendations. They're hamstrung by the lack of funding that they receive and their ability to do to have other options to monitor people. The TV. So basically, there's a big screen TV in the courtroom, and that's where the client is. So when we drive up from the jail, the client doesn't get brought, and you get basically a shot of a room with a bunch of guys, because this is I'm mainly referring to the male docket, but at the women's courthouse, it's the same deal. It's really an inhumane, kind of dehumanizing. I mean, it's a really bad picture, an image to have in your head, one that I've almost just kind of become immune to and kind of callous to. But it's just people in yellow jumpsuits. The judge will oftentimes, when the person's case called, say, raise your hand. And I wonder if sometimes they don't even look up. It's almost a gesture to say, oh, I'm acknowledging that you are that person. But there's no assessment of that person's being or essence or this is a determination that a judge is making about whether a person's going to comply with their orders when they get released. It's really difficult, I think, to assess that person when they can't even see them in person, and it's really unsure as to which one they are on the video screen. And the feed is often bad too, as I'm sure everyone's experienced with video conferences, that the voices go in and out. We don't even know if all the information the judge is saying is being heard by the client, whether they're hearing our arguments. We have no private line of communication, so we're often yelling at the client not to say anything that might be used against them later on. I had an interesting hearing one time earlier this year where I represented a deaf client, and there simply was no way to get the interpreter in the jail to interpret for the client. So that client was transported to court. And it was an alleged assault. I think it was a domestic violence case with, and the victim was a deaf woman, alleged victim. He said that it was like a mutual fight. Didn't have a record. But that was a typical case where the judge really would likely hold the person based on these crazy allegations because it was a domestic situation. The sympathy that my client evoked from being there in the courtroom, it was unmeasurable. I mean, you couldn't replicate him being there. I mean, I was trying to explain to my judge the situation as to how difficult it must have been for the police to communicate with these two people when they went to arrest them, and that it easily could have been misinterpreted in the police report as my client was contending, and they released him. And I don't know that that would have happened if the guy was on video, but not, it almost never happens. This is when things are normal though. So none of this is happening right now. We are not going to court for these hearings. We will get to what is happening with that in a minute. So when you have the hearing, the release options, you can be released on your own recognizance or reconnaissance, however you want to say it. But that is basically you're out, and you are on your own. A bail can still be set despite reforms in the bail law. Bails can still be set at anywhere from $1 to whatever. You can set percentage, judges can set percentage options that are allowed to be posted on bail. When a bail is posted, you can pay it yourself. You can use a bondsman who is going to charge a fee. When you pay yourself, once you go to court and you appear, the money is given back. The collateral is is basically yourself. Once you appear in court, you get the money back. If you use a bondsman, the bondsmen are insured. You pay a percentage to the bondsman, typically it's 10%. They'll charge late fees. They might let you make payments on the 10%, but you're never gonna get that back. Once you appear in court, the bondsman's gonna get everything back, even though they don't even have to put up the whole amount, but they're still going to collect on that fee, the 10%, whatever it is. If it's not paid on time, they're gonna charge late fees. Obviously, this system rewards people who have money. When you have a system in Baltimore that preys on Black people disproportionately, the bail system was a hindrance to Black people more than anyone else in the city. But this is where BALT has really stepped up. They kind of came out of the uprising and established bail funds. Maybe people have contributed to that. And the same thing's going on right now with the COVID crisis. Because of the desperate situation with incarcerated people and the conditions of prison, people are using these funds to bail people out. And I think Matt can chime in maybe later on about the difficulty in posting bail, because that is never a straightforward system. Even when you secure the funds for a poor person, you pull it together, whether you get BALT, and there's other public interest groups that are doing great work in Baltimore. You line them up, and then you can't find literally the right entrance to go in to post the bail on the right day, or the right guy's not there, or you don't have the right check. It's not written out the right way. There's always another option that judges like are unsecured bails, which they're kind of silly, but if it's going to get the client out, we're not going to argue with it, but it still is essentially a regressive tax on poor people if someone was to not show up in court. It's basically like an IOU. As long as you show up in court, you never put up anything to start with, But if you were to miss court, you're on the hook for an amount, I guess, until you show up in court again. It's really unclear. I don't think the judges understand it that are ruling that way, but they just can't bring themselves to say release on your own recognizance sometimes. So they'll do that, and we'll take it because it gets the client out. You can be released on pretrial supervision, which is like a pretrial probation. And unfortunately, they're really limited beyond that as to the way they can supervise people. Home detention is another option. There are two modes of home detention. There's free home detention and private home detention. And I want to go into that real quick because that was really on the back burner before COVID, but judges are recognizing the crisis in the jails. As I explained, the other options are so limited, pretrial is so limited in their ability to supervise, that home detention is now a real viable alternative, even for serious cases, which is the majority of what's in, and serious is defined by the state. I think a lot of them are stupid, but, and I use stupid as a pejorative, but they really are overcharged sometimes and mislabeled. So, you get into this category of serious or what they consider violent, and those are the majority of people that are held in. After bail reform, a lot of low-level offenses are now not held anymore. They're released by commissioners. They're released by judges on their own recognizance at this initial hearing. There's still bail set. There's still people held that maybe are on a probation or this or that, which is still unnecessary. And these groups are still working like BALT, Out for Justice, and they're still bailing people out because it happens, not nearly to the extent that it used to. So home detention. A judge has an option at the hearing to declare that someone is eligible for private, again, it gets so confusing. They're eligible for public, which is institutional home detention, run through the Department of Safety and Correctional Services. So what a judge is doing is just basically stamping a court file and saying, yes, this person is eligible. I'm not going to let them out right now. I'm going to let the Department of Safety make an assessment on that based on their record. And there's guidelines for it. Certain charges are totally ineligible. Certain people with certain charges within 3 years are totally ineligible, no matter how innocent they may be on the current case. And judges don't understand that. So they think that they're doing us a favor or throwing us a bone. We know that our client is completely ineligible, and they think, I made him eligible. I'm not going to let him out, but I'll let the jail decide it. It's free, but judges do not understand also that on a good day, the process is a month from when you have a hearing until your eligibility is finally determined. I had a client that was released a couple of days ago. It took about 2 months. There was a period during the crisis where judges were doing this because they don't understand the difference between private home detention and this institutional version. And clients weren't being assessed at all. There was like a month-long backlog in March, early April, because the staff reductions at jails were so severe that there was no one there to even start this process. It seems to be back up and running, but it's still very backlogged and very hit and miss at different institutions. The other version of home detention is a private company. There are basically two companies, ASAP and Alert. A judge can release anyone on these. Doesn't matter the charge, could be a murder case. Basically what they have to do is release them on their own recognizance with a condition of private home detention. So it's on the client, it's on us to kind of secure the funds for it or make sure the client has it. And that's where BALT comes in again, paying these fees. This is a money-making venture here. So these companies do the same thing that the institution does for free. They basically can set the parameters of the monitoring to 24-hour lockdown, go out 1 hour a day for a walk, go out Tuesday, Wednesday, Thursday for a job. it can do all that. So the problem with this is that, as I have at the bottom there, it's sort of a regressive system that preys on the poor. It's going to, again, this is institutional racism. I mean, when you take a policy like this and just keep using it, and the population that you are that you're setting up with the service is majority African American, that's de jure racism. That's institutional racism. Whether the judge is doing it on purpose, whether the system has set it up that way, it plays out that way because that's the population who is now on the hook for these fees. That's who BALT is posting for. Are there white people? Sure, there are, but the majority are Black people, and that starts with the way that we police our city. So the judge can also set any other condition for release. I mean, if they want to put in order, Aunt Edna, check in with Aunt Edna at 10 p.m., they can do it. And you know, and the reason why you may say that's crazy, but remember, we're in the courtroom during the bail review, and Aunt Edna could be sitting there. Judge may see that Aunt Edna looks like a drill sergeant and could say, you know, you need to check in, and Aunt Edna, if he's not checking in, give me a call. Whether that will actually happen, I don't know, but it certainly would have an impact on many of the people that I represent who if they have someone maybe in court that are there that they think highly of or respect or revere. So what can a judge consider during a bail review? This is where it kind of gets difficult for us. The nature, this is all taken from rules, which are basically the laws that control bail reviews. So the nature and the circumstances of the offense, evidence, the potential sentence, which is in play for the crime. What that is a lot of basically what the case is going to be about. And we as defense attorneys many times want to get into that. And judges will shut us down. They will say, and it's a total bullshit line that they spew out, and some defense attorneys have even, it gets regurgitated and repeated so many times that it starts becoming a truth, even though it's not. That at the bail review, the charges as written by the state are supposed to be taken as true. That is not law. There's nothing that says that at all. And the obvious response to that would be, well, what if the charge papers say that the sky is pink or the sky is green, and we know that the sky is blue? I mean, there are charge papers that are completely illegible. There are statements of charges that defy logic. If you want to know about some of the cases that are brought into court, the most telling thing that I can say about some of the charges that are in court right now, our mayor, the incoming mayor who won the Democratic primary, has a pending case against him. I mean, think about that. He was never arrested for it. It was a summons case, but it's a criminal charge where if the average person who's charged with it, maybe they might have a record, they would have gotten arrested on it. And they would have had a bail review hearing where we would get to the nature and circumstances of the offense. The mayor still has a pending case. So think about what would have happened to an average person if they were in a bail review hearing on that document. And that's our future progressive mayor. Defendant who also has a cross complaint pending against the person who was supposed to have hit him. The defendant's failures to appear in court are also considered.
Herschel's police reports.
What'd you say, Matt?
Herschel's police reports.
Yeah, I mean, that's an excellent point. So Matt says Herschel's police reports. I mean, there are problematic officers, and the one that Matt named is Daniel Herschel. So when we know who they are, and they still come up not hurtful so much because they're not making arrests anymore, but when problematic officers come up and we're trying to argue to a judge, even if it makes sense in the report, this cop can't be trusted. It's totally fair game for the hearing, but you're really depending on a judge to be able to decipher that and to have the experience to know what the value of the case is. A lot of judges have absolutely no criminal law background and don't know what the value of the case is. They don't know a Fourth Amendment violation on paper when they see it. They don't know what a shady set of charges looks like. And they really defer to the state often, frequently, and they're just going to go with the charges. So a defendant's failures to appear in court, these are important factors because the pretrial status has to account for whether the person is going to show up in court. Also relevant is the defendant's background, their family, work, where they live, because those show ties to the community. Pretrial services, as I was saying, will make a recommendation. Sometimes it's a little bit crazy because they sometimes will sound like auctioneers running through somebody's record, like 96 position with a dead 82, and based on that quick rundown, you'll get a recommendation. Sometimes it's favorable and you just roll with it. Sometimes it's not, and you kind of have to be on your game and call them out on it. Sometimes they're saying the total wrong information, or they're saying things that were not convictions that they're mislabeling as convictions, or reading the charges wrong, because even attorneys have trouble deciphering criminal records. And of course, the state's attorney's recommendation is going to be taken into account by the judge. They're very formulaic in what they're going to do. You would think that we're in court. So much of what we have is captured on camera now. You would think that if there's a legitimate issue with the case, we could just step back and explore that at the bail review hearing, hear the state's actual position on what's in the evidence. It never happens. We'll have bail review hearings where we have the quote unquote victim in the courtroom saying that they filed false charges, or what the police wrote was wrong. They didn't even want the police called. Judges won't allow them to speak during a bail review hearing. Some do. Some will take our representation as to what they say and just point to them in the courtroom. Most of us shut it down. And we know that case is heading nowhere. In 30 days, it's probably going to get dismissed, but the judges don't want to hear it. Their line to us is, this is not a trial, this is bail review. So we can also present any other information. It's kind of a catch-all at the end of it. A big thing is danger to others and danger to themselves. So when you go back to the factors, it's really important to know what everything is for. Bail, the concept of bail is supposed to account for number two, the defendant's failures to appear in court. What bail does, remember, it's a collateral, it's a down payment to make sure that they show up in court. That's why it's such a regressive tax on the poor. But it's like you're taking a piece of someone, you're cutting the pound of flesh off before trial even starts, just so that they show up to get it back, or that they're not out too much money. That's what bail's supposed to account for. Supervision in terms of home detention or pretrial services like the pretrial probation officer, that is where the danger to others comes into play, and danger to society, the charges themselves. How do we account for safety? So judges will very often confuse the two. And again, if it's a situation where a judge just does, because I'm going to explain to you in a minute that the bail is really disfavored now. So it's really you're in or you're held without, you're in and you're held without bail, or you're released on your own recognizance with one of these modes of supervision, or just on your own. So the idea of setting a number bail, it happens infrequently, but when you do, you're really supposed to be accounting for appearance in court. But judges will do it because they know it's kind of a BS seriously charged case, but they can't bring themselves to release someone. They don't want to be in the newspaper for the repeat offender, the ubiquitous repeat offender, which is an aberration, but it's what we continuously hear, or the domestic abuser who's going to go back to his victim. There's absolutely no faith in the individual that they're going to comply with any of these orders that the court sets. And I blame judges for a lot of things, but I think we can all agree, and where we're moving towards as a society is, if someone gets out and does something horrible, it's not the judge's fault. First of all, we have a system that is completely ineptly equipped to monitor people. So how's that the judge's fault? And clearly the judge doesn't intend to do that, but they're worried that they're going to get the blame for it. And judges that don't come from a criminal background really have that. So in addition to all those factors, we went for about a month without these rules in effect, but we were arguing to judges how serious the virus condition was, because what we're doing now are bail reviews by phone. There is no court that's open. So our clients are in jail to do the remember I told you the public defender shuffle. All of that is done by phone now. So if you're arrested for an initial bail review, you've just had a charge and you're coming up for your bail review, the public defenders who are assigned for that bail review duty, they call into the jail that morning and they get interviews with the clients. At some point you have to wait for a call back, and then you have to have client after client get on the phone with you. Then you have to hang up and wait for your call-in number, and you call in to a judge who's physically in the courtroom. And again, the clients are by video on for the bail review process. So it's really even worse now, because we can't even be there to making an argument over the phone is not as persuasive. I guarantee you, this discussion would be better in person. Court is better, and everything is more effective. Persuasion is easier in person. So we've been making arguments since March that we've tried to persuade judges about how serious the factors of COVID-19 are, but the Court of Appeals actually put it into the rule for those other conditions, just along with dangerousness and ability to appear in court. These factors, whether the defendant suffers from pre-existing conditions, displaying symptoms about the facility, all of these things are now, you would think, this fit into that catch-all with anything else a defense attorney wants to argue. But they had to put it into writing because it wasn't getting across to all judges. But it's there now. And so because of this, and because of the real emphasis on the virus, remember how I told you before, if you look down at the bottom of circuit court, we are able to do second bail reviews now. So if you have the initial bail review hearing for a serious case and things don't work out, person's held without bail, you can go back into circuit court and file either a habeas petition, this gets into the weeds a little bit, or if the case is already in circuit court, you can file a bail review motion, which you really couldn't do so easily before. And you can bring up all of these factors, which probably was done initially, but this is a dynamic situation and things are getting progressively worse at the jails. Let's see if I can go over to, okay. So as you can see, this is what we're dealing with at the institutions. It's kind of hard to discern everything, but it's really important to note that Baltimore City's institutions are 5. There used to be a Baltimore City jail system until Governor Hogan shut them down about 5 or 6 years ago. That system was central booking in the old Baltimore City jail building. There was also an annex.
Hey, Todd, are you trying to share the COVID numbers?
Yeah, can everybody see it?
We don't see that. No, I still see the PowerPoint.
Sorry. There we go. Everybody see it? Yep.
Yeah, we're good.
Okay. So what you can see listed there in Baltimore, BC, BIC, Baltimore Central Booking Intake Center, that is central booking. So let me step back again. So when Hogan shut down the Baltimore City jail system, those are all right in the Madison Street area, Eager Street. But now the only building that's still operating there is central booking. There are other facilities there that are prisons, which means that people are coming from Baltimore and throughout the state to serve sentences there. But the only pretrial facility there that is entirely pretrial is central booking. Nearly all of the women are housed in central booking. And then you have men that cycle through after about 30 days, they're going to be moved out to a different building. So there's not enough room to fit everybody. There's nearly 2,000 pretrial people or people that are serving short enough sentences within the city's pretrial system. So you have to move them to different buildings. One of the buildings is a prison that's right there. It's called MTC. We have a bunch of clients there. A handful of clients at MRDCC, which is a tower building up at the corner of Greenmount and Madison. But then we have people housed in Jessup, which is absolutely ludicrous for us to have to be able to do that as attorneys for Baltimore City residents predominantly who are being arrested, to being subjected to that in terms of their family being having to go out there to visit them. And that is a prison. Everybody knows Jessup's a prison. They also put women out in the women's version of Jessup if they're out there. So it's this smattering of things that Hogan has never really put together. Most elected officials in the city don't understand that, but it's just really appalling. And it's kind of all coming to a head now. As you can see the numbers here. This is from Monday. They publish this on their website once a week. Who knows what the hell this means? Positive inmates. As of when? You know, it's really, I think what's covered up by us there is recovered. But is that contemporaneous? Like, is that positive inmates right now? If they're not positive right now, or if they are positive right now, where are they? We know from our clients that people are being quarantined, people are being hospitalized, then brought back to the detention center. When you see that one staff death, I knew her. She was probably the most outgoing, friendly corrections officer, one of the most dedicated staff that we know. Corrections officers are not police officers. They work integrally with us, with courts, even with prosecutors to get stuff done in court. Our clients generally get along with them. They take care of people in jail. We have problems with them, sure, but not that woman. And I really wonder what's going on there, because we're really hearing bad things about the women's section over there right now, and it's scary. So we have to impress all this upon the judges, remember, because of the new rules. And it's really hard to do that when the numbers suck and the reporting sucks and the data is inadequate. So when you're held, if you have a district court case, remember those are misdemeanors, you're going to get a trial date in about 30 days. This is when things are normal. If you have a felony case, you're going to have in 30 days a preliminary hearing court date. That will never happen. You will be indicted, which means a grand jury will review the facts of your case. Generally, they say a grand jury would indict a ham sandwich. And then about 45 to 60 days later is going to be the time period where we need to pick a trial date, which is going to be about 100 days out from your arrest. So it can take 6 months to a year to get a trial on a normal day. Sometimes we need that as the defense to prepare. Not most of the time, especially if the state would just get us evidence on time. Everything's electronic. I don't understand why they can't do it. I don't understand why they're not doing it now with courts closed. I mean, we're at home. The police send them files. They send them to us in emails. We download them. It's not rocket science, but it's not happening. I literally had to file motions to get the state to comply with the rules that say you're supposed to give mandatory discovery within 30 days. And it's really problematic because it's not like the evidence is going to help us, but it certainly is something that clients want to look at. The reality is right now with COVID is that trial dates mean nothing. So this trial date in district court at 30 days, they're being postponed without us having a case in court. Right now, we're kind of starting to not go into court, but call up with the judge and set new trial dates for cases that are in circuit court. These are the more serious felony cases. But we're setting cases in October because that's when the chief judge of the Court of Appeals says that jury trials can start. But who knows how that's going to work. I mean, I can't imagine that most people want to go down for jury duty, or that the court, with its outdated structure and ability to deal with things on a normal basis, it's just not equipped to handle all of this. However, we are having emergency hearings. The judges have been good about setting in bail reviews for cases. These are serious cases that are in circuit court. Serious is defined by the state, again, or just felonies. Some misdemeanors that where they've moved up and asked for jury trials. So we can have these bail review hearings that were very difficult to get on a normal basis. You can essentially have a second bite at the apple and argue all the normal factors, like the case stuff, but you can also go into the COVID issues. So what happens when you're stuck? If you're held without bail? Obviously, jobs are hard to keep. Finances are down the tube. Today's the 1st, so rent is just next to impossible now with the virus situation. But imagine if you're locked up as to what happens with you. You just take, 60 days off from your job and your life. Think about people that you support, and whether that's financially or just assisting with kids. I mean, if you have a dog and you live by yourself, what would happen if you didn't come home one night? The jail conditions are horrific on a normal basis. With COVID, what we're hearing is that people are in dormitories where the beds are not at safe distances apart, where people get shuffled out maybe for isolation and then returned. There's no mandatory mask wearing. There's no ability to wash your mask or sanitize. And representation is really challenging because we're betwixt and between about going into the jails ourselves. It's really dangerous to possibly, if we're asymptomatic and we're bringing it in, or we're going in, even though they're not going to let you have contact with clients. The visiting facilities are just not as disgusting as being in jail, but to say that they're sterile and cleaned, I would have to doubt that. So because the governor has this fragmented system, every institution treats our ability to contact clients differently, and we have to develop this piecemeal approach to getting phone calls at institutions. There's no ability to Skype with inmates. We can't present the evidence to them right now. It's not like there's court, but if you're held in jail, you probably want to know what's going on in your case. We can usually get them on the phone, not immediately, but to show them stuff is next to impossible. So when you're in jail, people are often forced to plead guilty because postponements are sometimes inevitable. As good, I think the court has gotten better. The virus situation has completely destroyed all docket situations. There's a total backlog now. Um, but people plead guilty because they are avoiding overcharged cases, avoiding mandatory minimums. Um, when you're in jail, um, it's really difficult to try cases because the courthouse is ill-equipped to have people, the elevator systems are not separated. So you have to do this tiptoeing operation of people walking around with shackles. Jurors can't see that because it creates a perception, even though most people can figure out they're locked up. And then, the question comes up like, if it could be worked out for probation in the end, why were they sitting there to begin with? And the constant retort to that from the court and the state is, well, they've pled guilty now. I'm not sure what the logic behind that is. So these are some older numbers, but I think they're still telling. Remember that, so because Hogan fragmented all these systems, or the jail system, even before that, the state controls our pretrial budget. The state controls our pretrial facilities, whereas other counties, Baltimore County, Southern Maryland has a group of counties, Montgomery County, they have their own pretrial, they have their own jail. They run it, they fund it, they have their own pretrial system. So this is a state budget, and 90% of it in 2011 was going to our pretrial facilities. And it's not the same now, but it's still this disproportionate amount that's going to the release services program. Those are the people, remember that I was telling you, come into court, make the recommendation, and can act as probation officers. And these are the costs that it, costs $100 a day in 2011. We all know what the cost of medical expenses has done since then. So that's what you're paying for: dental, medical, feeding. I don't think pretrial services has gone up too much, and at that disparity, I don't think even if it did that it's going to be. So, those are some of the savings that you can get to. Just going to move through these pretty quickly here, so we can get to some questions. The thing is that when people get released, everybody thinks they're not going to show up and that people are going to get killed. Well, people show up, first of all, and you can see the system that we have now where a lot of people are being held without bail on serious charges. Near as I can tell, that ain't doing nothing for the murder rate in the city. This kind of shows that even in the 90s, before the advent of big bail bonds business, stuff was kind of backwards as to who's held. I guess I should go through this real quick here. So lobbying really played a big role in what happened with bail, why it was that way. Because the bail bonds industry really had their hand in the pockets of legislators. So that's where we got to with bail. However, there was reform. And as I was saying, even pretrial embraced this. So they put into the rule, even though this is all, it should have been there in the back of people's minds. So they encourage judges to release people on their own recognizance when necessary. They can use this unsecured bond, which is kind of a chicken kind of a move. But the preference should be given to additional conditions without financial terms. That language, and you'll see it throughout these things, is really where we move towards. Again, the least onerous condition or combination of conditions of release set forth in this section. So bail is really considered a hardship now, though it's still misapplied. So this happened because of the Attorney General getting on board, because there was a huge movement in progressive, quote unquote, progressive circles. You know, you had your Bernie people, and then you had to have your progressive prosecutors get behind it. The whole time, though, we've been arguing this. Organizations like BALT, Out for Justice, is a good local group, the ACLU, Leaders of a Beautiful Struggle. Or, I mean, these people lobby like crazy, and they really are thoughtful in their presentation as to convincing legislatures and really showing the hardships of our clients. I mean, we're in the courts battling judges. We're not so much great with the legislators, and these groups really do well. So if if you're checking out BALT, these other groups are doing great work too. But what's happened with the rule changes is that most low-level offenses are released, whether it's to the commissioner or the judge. They're finding alternative means. Still not great. But what's happening is they're saying, I can't do bail anymore, so you're held without bail. So any whiff of violence, if it's a gun case, even if there's 4 people in a car, 1 gun, they're probably going to hold you without bail. And the crazy thing is, if you get a good judge with one of the people in the car, another person in the car could go to a different courtroom that day and get a much better result. I've seen it happen with my own clients, and it's just like, man, you got lucky, because if you were in the courtroom next door, that guy would have held you without bail. And that's for 6 months to a year, even though we know that our guy is not the most culpable in the car. But number 4, there's still no real second shot at bail reviews on a normal day. We're doing it a lot now. The judges are being great because of the COVID situation. But we got to consider whether this is going to last. Are they really going to keep considering home detention? Are they really going to keep bringing in cases to review them as to whether they should go forward? I think this is where Matt can come in and say, I mean, the idea here, the federal system, they don't have bail. They did away with it, but they hold a lot of people, so it's still not great. But they have a more robust pretrial services agency. They have funding for it. I mean, that's federal money. But what we need is more options. BALT is a stopgap measure now to fund people's private home detention, and it shouldn't be that way. That's institutional racism at its finest. And I think that's where I'll leave it. I mean, this is coming from someone who benefits from having, we need clients as public defenders. I mean, and then it justifies our budget. But at the same time, we're altruistic. I mean, we are state employees. That's a nice thing about, we're going to have a system. So what I would love is to not have work, to not have to do these bail reviews. So I think, this is coming from a place of genuine concern when you hear that, like, we need this reform so that we're not doing these things, so that there aren't as many court cases, so that people aren't held, and there aren't these ridiculous bail hearings. I'll leave it at that.
Thank you, Todd. So we do have, I don't know, Matt, did you want to share something before we get into questions? We don't have much time left, but I don't know if you wanted to say something.
No, I'll follow your lead, however you want to go.
Okay. So just really quickly, the questions I'm doing, I'm going to go through the questions that were in the Q&A. So Todd, will we be able to distribute these slides after the webinar? Okay, cool. So that was a quick one. So there was a question about who is present for the accused at a commissioner hearing. Is it state attorneys?
I mean, no one. It's a dark hole. I mean, it's in the middle of the jail. It's the commissioner, court-appointed attorney that you just met and doesn't know you, and the defendant, through glass. I mean, you can't access it if you wanted to. I mean, there's no way to get in there. BALT actually, we have a lawsuit pending. Like we sued the judge, the chief judge of the district court, and we sued the administrative office of the courts because they don't even publish who the commissioners are. Like the District Court of Maryland has almost 300 commissioners, but they don't tell you who's determining people's freedom. They just tell you a four-digit code of this four-digit number determined if this person is going to be released or not. So we made a demand based on really First Amendment right, especially during COVID. We can't even get into the court files to see these four-digit codes to try and crack the codes of who they are. So we're fighting that out right now.
So I think the question, I don't know if we've even talked about the fact that this whole commissioner system, there's no transparency whatsoever. I think the question was kind of get through who represents people at that commissioner stage before bail review. And it's really court-appointed panel attorneys and
a lot of them are defense attorneys that private defense attorneys that come into court regularly. A lot of newer attorneys will do that as a way to get into the system.
Gotcha. Is the same lawyer that represents the client at a bail review the same lawyer who will represent them with their case moving forward?
It depends. It's the ideal way to do it. We try to do, it's called vertical representation. But there's so many arrests, and the way, especially now, it's very chaotic. So it really depends.
I know you mentioned, you gave the example of a person that was deaf, and Gabriella had a question. Isn't it an ADA violation if the city does not provide a translator for a deaf client?
Yes, they provided a translator, but we had a translator. The point I wanted to make there was that it took a translator to get somebody actually present in court, where everybody else who didn't have a disability was disadvantaged during that hearing. So this guy, who is normally disadvantaged because of his disability, actually benefited from being deaf, unfortunately, because everybody could understand his situation being there in person.
And whereas everyone else you see them on a TV screen and they're not in the courtroom. I think that's the distinction we're trying to make.
Yes, it's hard to even tell who's who on the TV.
Yeah. If someone is eligible for institutional or free home detention, they will remain in jail until processed, which is generally about a month in best case scenario. If someone is ineligible, what happens?
They remain in jail. It's really bad, because it's like we're not a part of the process at all. Like when the judge determines that they're eligible for institutional home detention, especially when it's like a secondary bail review. If it happens at the first bail review, that information will probably get forwarded to the jail. When I did mine for my client, because he had already had a bail review at the time of arrest, and then we were having a second one because of COVID, no one let the jail know. So I did an interview with him on the phone. I was like, how's this going? He's like, nothing's going. So I had to get his counselor on the phone, and I had to start the process. So they don't, it's weird. And then I just keep having to call and say what's going on with it, and they can do whatever they want.
What exactly are the qualifications to become a judge?
Knowing somebody.
You probably shouldn't do these presentations. I mean, I wrote an article about that because I ran for judge, and then I also applied to be a judge. So there are certain, like all of these district court judges that do the initial bail review process, they are all just straight up appointments. There's never an election process. In circuit court, however, where you have jury trials, it's kind of a hybrid system. Whenever there's a vacancy, they appoint someone to fill it, but they have to stand election that whenever the next election comes up, and then they're there for 15 years. So I tried to run against them, and you're allowed to challenge them even if you're not appointed. So I tried to do that and was unsuccessful because all the ones that are always judges, they have this big fund that they run their campaigns through. But you can also apply to be appointed. And that's a joke because it's who's tight with the bar associations. They make recommendations. A lot of the bar associations have committees where they interview the judges, and it's really funny that people who sit on those committees end up applying to be judges because they're the ones that have interviewed judges before. I can't say much about the process. There are some really good judges, though. It's just there are some people that have no business being judges.
Why do you think, why is there such a lack of understanding on the impact bail procedures? I'm sorry, why is there such a lack of understanding the impact of bail procedures on defendants by judges? Is it an issue of culture or lack of time?
Yeah, I mean, I'm not sure what's meant by culture because I'll say that race is definitely not dependent on the outcome of these proceedings. There are just as many difficult African-American judges as there are white judges. But I don't know what anyone's personal experience is. I think what it comes down to is what their professional experience is. And if they haven't represented people, or I don't know, maybe they were a prosecutor their entire career and only saw things from that way. See, I think the benefit of coming from the defense side or being a public defender is, I mean, I still experience crime in the community and know how victims feel. Everybody does, but as a white guy, I probably wouldn't know the Black experience as well as I wouldn't be exposed to it like I am now representing people. So I think it's a much more balanced person that you put up there when you get that side of it. But there's exceptions to everything.
So I have two questions I'm kind of going to put together, but what do you see as the best avenue for change? What does it look like? Is it legislative? Is it litigation? What would that look like specifically? And as a follow-up to that, we could talk about alternatives, which may be the best avenue for change, but I guess let's talk about how we would get to that change. Is it legislative or litigation?
Go ahead, Matt.
Yeah, I mean, I'm much more of a fan of litigation. I'm on, that just because I think it's a much easier route than making friends in Annapolis. It's easier to yell in the courtroom. And I think there's a lot of interesting arguments here. And I think bail and home monitoring, raises a lot of constitutional violations and a lot of violations, under the Maryland Declaration of Rights. I've been talking a lot, with one of our fellows. I think he's on, right now, Mike. And I'd like to shout out.
That's who asked the question, by the way.
Mike? Oh, okay. Well, with Mike, I'd like to shout out. We do have a lot of fellows working with us at Five Folks this summer. Mike and Destin and Layla and Shanze and Amela. I'm extremely appreciative of. We've been able to just help the research that we're doing. Just skyrockets. We can do so much more. And bail is just one of the areas, and look and see what is being successful around the country, because we are certainly pissed off at the situation, but where we go from here, I think has been an open question. We don't want our change to backfire like bail did, because we had a big win in changing the bail rule in 2017, and it just resulted in nothing. But we see like bail and pretrial detention doesn't look the same, not just throughout the country, it doesn't look at the same throughout the state. Like I was talking to a public defender in St. Mary's County where pretrial earlier today, and pretrial detention looks completely different there than it does in Baltimore City. In Baltimore City, it's like basically a binary option. You either released ROR, or you're held without bail, or you get the economically violent release of home monitoring from held without bail. But even down in St. Mary's County, they have ROR, or you're released under 4 levels of community monitoring, and then if you're not on one of those 4 levels, you're held without bail. And they're ranging from once a week you go somewhere to check in, once a week you go somewhere to check in with your analysis, which I find extremely problematic. But then the 3 and 4, you have an ankle monitor. One's you're just being surveilled in the community, and then the 5th or the 4th is you have the ankle monitor and you're just on home detention. There's also a New Jersey model where you've got different tiers of release, where at the lightest you call in every other week, or you have to check in every other week, or you have things like being on an ankle monitor and you can't leave your house. So I think what we need to do is give judges more options. I'd like to stay away from urinalysis, because I don't think it's the state's right or involvement, especially if we're saying innocent until proven guilty. I also want to stay away from electronic monitoring as much as possible. Another big question in these this space is risk assessment tools. A lot of states, areas in Maryland still does kind of use them as looking at someone's situation, priors, their ties to the community, what the charge actually is, and they assign a number to each of these factors, and then they add these numbers up, and based on what their number is, that results in what their release should look like. And while the results have equated to a lot more people being released generally, the argument is strong. I think it kind of also sends a message that people are numbers, and we can estimate what someone's probability is, which I think is also kind of bullshit. We just need to be seeing humans as humans, and not breaking them down. And I think there is, no matter how you come up with a matrix, they're always going to be inherently racist. So I think we should simultaneously be looking at litigation, if anything, to raise media attention at how unjust these practices are, while we look at legislation. And I think that's what we're doing to bring about a more tiered release system, so judges have more options in front of them. But in the end, I'd stay away from a risk assessment tool, which is up for debate, but I just don't know if giving judges no discretion is the best option. But some folks might push back on that.
Okay, we have 2 more. When you say that judges have to consider factors laid out by the Court of Appeals and then put their bail review decisions into writing, do they have to actually explain or justify their decision to hold someone with the high risk of dying from COVID? And they give for example, John Doe has a history of severe chronic asthma. However, they have 2 prior convictions for first-degree assault. They're charged with murder. Therefore, I believe they pose a high risk to the community. Do they have to explain or justify their decision?
Yes. So what they'll do is either hide behind danger to the community or flight risk, which is the ability to appear in court. So what we're finding with a lot of these COVID bail reviews is that even the state is not really fighting us on whether a person is vulnerable or how serious the virus is in a certain institution. We kind of get past that, and then we get into what the bail review is in a normal time, and it's just what's going on in the case. Does the judge really consider that a dangerous situation, and are they going to appear in court? So yeah, I think, yeah. They basically, yeah.
And I think the last question is probably a great question to end with. So how can someone without a law background help, and other than distributing money to bail funds?
I think raising the call right now, because once this comes to, I mean, just having the discussion, you know, posting about it, there's a lot more we can do. You know, I want to litigate the issue, but I think the legislation is going to be broad, you know, not just, you know, getting tools on the table. I think we need to strike down some of the guidelines that we have right now. Like, commissioners oftentimes will not be able to release folks. They're required to hold folks, you know, on violent charges, and no one knows what violent actually means. But call out Mosby. Mosby's, you know, making this, you know, parade of, you know, this political facade of being a progressive prosecutor when she, you know, in the courtroom, you know, fighting tooth and nail to keep, you know, simple possession with intent to distribute charges, you know, held without bail. Let folks know that, you know, hold her feet to the fire. So she's actually, you know, letting those charges, you know, go ROR. Let folks, you know, share posts that people are posting about the trouble that they're having when they go down to central booking to actually post, you know, bail out, hold the commissioners accountable for the bullshit that they're doing. Karen, you know, at JOTF just shared her experience of posting, you know, bail for someone. The commissioners, you know, do not work with us. You know, I showed up with cash in hand and they turned me away and said, I can't post a bail unless I'm a bail bondsman, which is absolutely constitutionally illegal. Karen was able to, you know, put that on Facebook, and it caught legislators' opinion, and now they're talking about it like it's a hot issue again. So just having the conversation and letting people know, you know, now legislators, you know, they want to, I mean, they want to seem popular, so they want to be on board with what folks are talking about.
Yeah.
And I'll definitely say that I know, you know, we talked about whether or not what does change look like, and whether or not it'll be legislative or litigation. And I honestly don't believe that the solution is a legal one. I think that we've seen historically, and we see now with the culture change is probably, right, the best way in which we'll, you know, even have courts that are ready, right, to make difficult decisions, judges that are ready to make difficult decisions, and elected officials that are ready to make a difficult decision. And so when we talk about people that don't have law degrees, I think that you should feel just as empowered as we do, right, with shifting that culture, right? And, you know, that means educating yourself on what's going on and making people aware of it, and making sure that the people that, you know, represent you and whatever level that they represent you, you know, are aligned with, you know, what you think the change should be. But as attorneys, I don't think that we should ever think that is going to be a legal solution, right? Because if it was, you know, we wouldn't be where it was, because attorneys are working on this day in and day out for years, have been working and churning the system, yet we're still where we are. And so we need to start working on changing the culture. And I can tell you, a year ago, we would have never been talking about defund the police the way we're talking now. That has been a culture shift. That has nothing to do with attorneys, nothing to do with legal workers, and everything to do with advocates and grassroots organizations making the call. And so I want everyone to feel just as empowered as, say, sometimes attorneys do, and sometimes we feel too empowered, because it starts with a major culture shift. And just making sure that everyone is aware. I guarantee you there are probably some things that you've learned tonight from Todd that we didn't know. You know what I mean? I work in it, so I may not know, but I think that awareness is probably the first step and key to, you know, shifting the culture. And Todd, I'll let you end.
In addition to the movement that we have, the virus situation, I mean, the movement's been going on, but the movement came to the forefront after the virus situation already hit the court system and opened people's eyes. And you don't need to be a lawyer for people to have seen the destruction and just the sense behind keeping people incarcerated pre-trial and everything like that. So I think everybody saw that. And these alternate release options, even though it's not where we want to move, as Matt just explained, from my perspective, we're making movement, and it's because of a stupid pandemic that finally has moved judges a little bit to consider what's going on in jails and other release options. It's by no means a solution, because as we've explained, home detention is a regressive system that's going to prey upon poor people and Black people disproportionately in the system. But it's movement. And it also is really forcing judges to consider, like, where are these other options? And so now we're having this conversation, and I don't think it's too, specific in terms of legal stuff for non-lawyers to know now that pre-trial options, we need them. We need things that allow people to be in the community while their cases are pending, so that they can get treatment, so that they can get back to their jobs and be more productive, because most of the time when they get out, there's no issue.
Well, thank you. Thank you, Todd. We are actually 5 minutes over, but I appreciate the almost 40 of you that actually stayed on, extra 5 minutes. Thank you, Todd and Matt, for this. I hope that this was definitely informative for everyone. And we will, like I said, we will post the recording on our website, and I'll let you all know when it's posted. So have a great evening, everyone, and be safe.
Thanks, Iman.